Morning. Welcome to Member Focus Monday. I'm Christina Schaefer, Social Media Manager for HAR. I'm joined this morning by Grant Harpold, HAR Legal Counsel. Grant, welcome?
Good morning.
Would you like to introduce yourself for our
Grant
viewers?
Harpold, Legal Counsel for HAR, and happy to be here on I don't know what kind of Monday morning this is.
A little dreary outside,
Dreary,
I guess, but observation of Veterans Day today. So
True.
Yes, that's good. So Grant joined us a few months back and we were discussing Trek advertising rules there. We had a really in-depth discussion about Trek advertising rules. We got very specific about different rules and things that have come up. And Grant did an excellent job of explaining those to us to where we could all understand. So if you didn't get a chance to check that out, you can actually see that. If you go to our Facebook page and go to our video section, you can go watch our interview with Grant then, where we discussed Trek advertising rules specifically. We invited Grant back because, since he does have such a great legal mind and there's so many ways that we can get in trouble in real estate, we wanted to have him back to kind of explain a few different topics with us today. So Grant actually did a presentation at HAR Engage called Avoiding Legal Peril. Just taking some of the trending mistakes, right? Things that people are doing wrong or things that are coming up that can get them in trouble. So that's what we're here to discuss with Grant this morning. So first thing I wanted to kind of ask you about, I hear this question a lot from members. My client only likes to communicate via text message or email. What are some ways that realtors can protect themselves or maybe just be aware of the terminology they're using in these communications?
Well, I think, we can't help but not communicate by text or by email. But I think, and I'm going by case law. This isn't so much me on the law, but it's really, there's actually a case from Houston that came out a couple of years ago that talked about terms that were in a email, which could apply to text or could apply to any sort of social media exchange. And in that exchange of email, the agent, the listing agent, was communicating with the actual buyer himself. In the within the email, there was price, there was a closing date, and there was a description of property. So if you have those kind of ingredients to kind of cook up the recipe that for a sale, that's all you need. And then the operative language that went in there to make an email exchange between that listing agent and the buyer was the term agree. And so essentially you had an email that went from the listing agent to the buyer saying, we will agree, my client will agree. And it laid out, it just said it's some square footage, and this was a commercial track, and it had price and had closing. I mean, it was, when you read it on initially, it's not very alarming, but when you study it a little closer, or if somebody is playing gotcha, they got that listing agent, because in that situation, the court found that, hey, there was an identity of the property, there was a closing, and there was a price. And those are the key terms to any agreement. I mean, the contract may be 15 pages long, but if you have those three terms in it, it doesn't need to be 15 pages. It can be a one-sentence email, which it was in that case.
Wow.
And so, and also in that case, the agent probably got a little bit outside his box by trying to distinguish between an option contract and an exclusive right to sale agreement. And he actually created an option for the buyer to buy the property at a future date at a certain price. So point is, email can create a contract. Text can create a contract. Any sort of social media that is documented electronically can create a contract. And so you got to be careful of that. And I've had people ask, well, if I put the disclaimer at the bottom of the email, this whatever I say above doesn't create a contract. I mean, that's in simple terms. I say that might be helpful, but that doesn't mean that it saves you or gets you out of jail. If you have the language in the email, it can trump the disclaimer language. So you still got to be careful. You can't have the disclaimer, then come to terms on a sale in an email and say, well, we didn't really mean it. We had a disclaimer. So, try to use words, instead of using words like agree or we'll do that, just use words like consider or under consideration, or we'll discuss with client, let you know. Just sort of, that's really where your disclaimer language should come into play, is in your email exchange, not so much at the bottom of the page in the standard disclaimer form.
Okay, that's good. So leaving it more open.
Open, right?
Or
yeah.
open terminology, open language. So it kind of brings us to the seller's disclosure. So what are some, I know you discussed the seller's disclosure, when you're at Engage as well. So what are some things that we should be aware of on the seller's disclosure?
Well, that's using your term aware, that's kind of what I and a lot of this is kind of refresher, and it's kind of been heightened because of the Harvey and the flooding and so forth. Right. But, the seller's disclosure is not so much personal knowledge. It's, are you aware? And so there can be a difference. I mean, you don't want a seller saying, well, I wasn't there. I don't know that. Never saw it. I don't have personal knowledge. But at the same time, if the seller was made aware of a prior situation because of the seller disclosure that seller may have received when it was a buyer, or maybe as far as maybe the seller heard, was told something by the neighbor. And so if these discussions are had with the seller, where the seller saying, well, I don't have personal knowledge, but I'm aware of this, well, that needs to be disclosed. Okay. And so awareness to me is a lower standard. Personal knowledge is a higher standard, and the seller, not you, but the seller is put at that lower standard on awareness, and also applies to you, of course, as an agent, a listing agent. If you are aware of something and the seller is not making that disclosure, then there's an issue there that needs to be addressed. If you have the knowledge, or if you have the awareness, and the seller is not acknowledging that issue exists. And so that's just kind of fundamental, going back to the basics of when filling out a seller disclosure. And I think I'm just going to kind of ramble on here, if that's okay.
That's fine with me.
I think in light of Harvey, I think you got to be careful that the seller's not just focusing on Harvey on disclosing, because Harvey has been, as further we get away from Harvey, it won't be so much, but Harvey is on everybody's mind. And somebody says, well, I didn't flood in Harvey. Well, that's not the end of the inquiry. You still could. I know of some homes that did not flood in Harvey, but flooded during Tax Day and Memorial Day.
Right.
And so Tax Day, Memorial Day, Allison, 2001, or any other event that may have been more localized, those still have to be disclosed if the seller and or you are aware about them. So the focus is beyond Harvey. And I think, so you as the listing agent, I think really have to, maybe probe and maybe push your seller on that issue. That's something that you should maybe really discuss with them, make sure that they understand what they're filling out there. And then likewise, as a buyer, that's something you should maybe, on behalf of your buyer, as an agent, as a buyer's agent, if you're in a neighborhood that flooded, and all of a sudden you see a property that's for sale that says there was no flooding, maybe you should press the listing agent on how that occurred, or why, or what, something more than something that that may cause you to question whether it's completely accurate. Maybe it is accurate, but I think as a buyer's agent in certain neighborhoods, you need to really probe on that. Okay. And just getting back to the, to the listing, the actual language, there's, if I can read it right here, it's owned to the property. You've seen it before. It's owned to the property into the structure. Okay, so owned to the property means owned to the property, meaning that if it rises above the curb and the water's all of a sudden now on the property, the property is what's inside the survey. So if the seller can imagine that, or if that, if the water comes up into the yard, then it's onto the property.
Right.
That has to be disclosed. Okay. And if it's into the structure, that doesn't just mean the house. That means the garage. That means an outbuilding. That means any sort of structure that is placed on the property in addition to the house, if water comes into it due to a flood. And so I think sometimes, and seller listing agent needs to be conscious of that. Sometimes the seller may not focus so much on that question about own to the property. They may morph that into the question about into the structure, and they're really they're really different questions that are being asked.
Okay, well, very good. So moving away from the seller's disclosure, but to talk about forms just in general, we've talked last time a little bit about using, verified forms, and you gave us some examples of that, but specifically Trek forms. Also, sometimes we may go into Zip Form or Transaction Desk or whatever transaction management program that they might be using, and maybe I search for, seller's disclosure, and maybe I find a Trek one and a TAR one, so that sometimes there's two versions of a form as well. So kind of two-part questions. What form should we be using? And also, if there's a TAR form and a Trek form, which one's the better one to use?
Well, my experience is that if there's a Trek form and a TAR form, I would use the TAR form.
Okay.
And I, by example, the seller disclosure notice. So the TAR form, I believe, is more comprehensive and more thorough. I think the Trek form, which I don't really see used that often, but the Trek form is really tracks the statute. So the Trek form is legal. It's kind of, if you will, the bare minimum, maybe with a few bells and whistles. And I think the TAR form has more things on it, more practical things, more input from realtors as to what should be on the form and is what's important to both the buyer and the seller. And so I, on the actual sale documents, I mean, that's a Trek form. So that's usually you're limited to that. But on the auxiliary documents, if you will, other sort of practical kind of documents for certain situations, use TAR form.
Okay. So if you have the option for a TAR form, opt for that.
That's been my experience. I mean, there may be an exception to that, but that's been my experience and what seems to work best because of the practical nature of why the TAR form was drafted.
Okay. Anything else on Trek forms that you?
Yeah, I mean, they kind of changed it up a little bit here with the recent rules and just some basic things. I mean, you're bound as a licensee to use on the sale or lease of property to use the Trek form, unless the seller or the owner of the property or creates it or provides it or a lawyer creates or drafts the document itself. Otherwise, you're bound as a licensee to use the Trek form. And that, like I said, and when I say use a Trek form on the actual documenting the transaction, meaning the sale of the property or the lease of the property.
Okay.
If you don't have a form, if there is no form, there's no TAR form and there's no Trek form, there used to be pretty, I say routine, but it would happen a lot where a situation arises and whether it be at closing or some part of the transaction, there is no form. And it's some unique situation and, somebody like me will get a call and we'll draft something to send it out, or the title company lawyer will create something. And so Trek has passed a recent rule that says it's trying to curtail that in the sense that if you do use a form that is not promulgated either by Trek or by TAR, it must have, and there's a list of things, it must have the name of the lawyer who created it or the association who it was prepared for. So there has to be some identity. Just imagine, I guess their thinking here is that on the Trek form and a TAR form, currently there's, which form it is because it's a Trek or it's a TAR. And so they're trying to say, if you're going to use if a realtor or a licensee, I guess, is going to use a form, let's have some identity on it. So it has to be
branded a little bit.
Branded, exactly. And so that's a good word. That's a good term. So they're asking that it be branded and it have some other stuff on it that points to the consumer or the people that are using it as to why it was created, who it was created for, if it's an addendum to a contract, if it's changing some terms in the underlying contract, that those need to be identified or that needs to be brought out so that the consumer. And I guess the point of all this is that it's to help make sure the consumer knows what he or she is signing. And I think there's some language on there that says it It's not a mandatory form. And so it's just sort of just think of it in the sense of, if you're going to go outside the box and use a form that's not promulgated, but it has to have the kind of promulgated type trappings, branding on it. Otherwise, that could be a TREC violation if it becomes an issue later on, and they look at the form and they say, "Huh, what is this?"
So Crystal actually asked a question, and I think this is kind of answering it here. She asked, "What if the brokerage had a form that TREC or TAR does not offer?"
So that form can be used, but it has to be identified as to who prepared it and why and who it was prepared for. So if a lawyer prepared it, the lawyer's name needs to be on it, and it has to have a title. And if it was prepared for an association like Houston Association of Realtors, then it would have to have that, in which we do on our forms. But if it was a special form that was maybe created for a special situation, it would have to again have that title on it or who it was prepared for. So the point is, it needs to have something on it more than just the broker's name. Absolutely. In fact, the broker's name should not be the forefront of the document. It should be, either the lawyer who prepared it or the association who prepared it, identifying the title of it, who prepared it, and for what reason.
Okay. Glenda is also asking, kind of to follow up on some of this form talk here. Can a non-licensee use TREC or TAR forms?
Well, that's no. TAR forms, no. I mean, those are technically provided for members of the association, so realtors. And so a non-licensee can use a TREC form, but not so much a TAR form, because a TAR form is available for its members who are realtors.
All right, that makes sense.
Something else on the and this is kind of refresher on the form stuff. You as a licensee cannot draft language yourself, that it changes the terms of the agreement. And you cannot pay a lawyer for your client, meaning if a lawyer needs to draft something, the client needs to pay the lawyer, needs to engage the lawyer, not you, the agent. Okay. It's okay still, of course. This is good news. You can still fill in the blank on the form. They have... I mean, when I was reading these new rules, I thought they were going to take away that ability for you to fill in the blank. So yes, you can still fill in the blank, but here's something else. Maybe some of you are doing this already, but if you add details to a contract, or if you strike language in the contract, even if initialed by the seller or the buyer, that's not good enough. What TREC is saying, you need to have something in writing, and so this can still be done electronically, but something in writing from your client authorizing you to either strike or add language to the contract. In my mind, you would think that would be covered if they initial it, but I don't think, we haven't seen an interpretation yet, but I think what TREC is saying, you got to go beyond that. You got to have that authorization in place before the actual change in the contract. And otherwise, if something comes up on that down the road, that's a TREC violation. Okay.
So that kind of leads us into, we talked about seller's disclosure. Now we talked about forms, leading into just actually listing in the MLS. What are some things we should be watching out for when we go to list in the MLS?
Well, the big thing now is making sure that you're granting to the MLS the authority to use the information you're providing with respect to a listing. And the specific issue, just to boil it down, is photographs. So currently there's been a lot of new lawsuits. We used to have these discussions about people being afraid of violating a patent, or there were all this patent lawsuits and other intellectual property kind of lawsuits. Now it's shifted to photographs. And so the photographers seem to be stepping out into the litigation world a lot more now. And so if you hire somebody to take photos of the house or the property, you need to be sure that you have either ownership of those photographs or a license basically for unlimited use of those photographs. Because the MLS requires that when you provide the information about a property, including photos, that you grant the MLS authority, pretty much unlimited, to use those photos, whether it be for a listing or for an appraisal after the property sells. And so those photos continue to have use to the MLS even long after the listing has gone away, or even the sale, if there was a sale, has gone away. And so it is important that you, as a licensee on taking a listing and then taking photographs of the property, that you either own the photographs, or B, you have a license from the photographer granting you pretty much unlimited use of those photos, because you're going to turn around and grant the same license or the same use to the MLS for them to use it virtually unlimited. And that's an MLS rule. I mean, that's an MLS rule in simple terms, but that's critically important that you have something in writing and from the photographer if you use an outside photographer.
Okay.
And we have a form. We, being HAR, has a form that you can use to engage the photographer that grants you the rights and ultimately grants MLS all the rights that they need. Or you can have your photographer engage contractually directly with the MLS. So we have a form whereby our MLS will contract directly with the photographer.
Okay.
And then those legal issues about license and use and all that stuff will be taken care of in that document. So I guess the point is, there's no excuse not to have this issue covered.
Sure.
It protects you, it protects your fellow members, and protects MLS. And so, it's a simple process. You can use the HAR contract directly with the photographer, or have the photographer use one directly with the MLS.
Where can they find those forms?
HAR.
Okay. So I'm guessing that they're in all our forms.
Yeah, wherever the other forms are is where those forms are.
That's basically what I wanted to know.
Yeah,
if they just search where the other forms are, are they going to find it?
They should. If not, contact us. We'll get them. Contact the MLS department at HAR. They'll be more than happy to get you on one if we can't find it online.
So in the member portal, you have your forms manager, and if you're using any, like I mentioned earlier, zip form, transaction desk, it should all be there in the form library. Okay, so we actually, just to back up a second,
Sure.
Hope asked, can whiteout be used on a TAR form?
Can whiteout be used? I wouldn't use whiteout, because I would just, if you're going to strike something, you would just simply strike it. I don't know that I would black it out or white it out or remove it. So that's just because, at least when you strike it, to the extent you don't have that sentence memorized, you can see what was stricken. And so I think it's important, especially if you're the buyer and you strike something, the seller needs to see what you struck out. I mean, I'm sure they can go get another contract, compare what was crossed out, but so when you white out, you can't really see it. So,
right.
So I would not recommend using whiteout. If you have to strike something, just use a pen or some sort of ink type of, whether online or physically, that marks through it with a line.
Okay. Selena's asking, why are TREC forms on the TREC website for public information?
Why does
TREC allow the public to use?
Oh, okay. I think TREC's a state agency. The public are citizens of the state and pay taxes, and so I see that's a good thing for them to have access to those forms. A, because it's a state agency funded by taxpayers, and B, it access to that information ultimately promotes people interest in buying or selling or leasing real estate.
Okay. So one more thing about, actually, Karen, I see your question about wire fraud. We're going to talk about that in a little bit. Jody mentioned, I was told to never use whiteout on a contract, any contract. So that's
Agreed.
just kind of following.
Yeah.
So Grant agrees. Okay, on the professional photos, if a client is reimbursing you for the photos, can the client provide those to another agent if they're relisting with another agent later?
Can the client provide the photo? Yes, whoever has the photos or has use or rights to those photos controls as to who they go to next or who may use them next.
Sure.
Yes.
Okay, perfect. Okay, and like I said, Karen, I see your question, and we'll get to that when we talk about wire fraud in just a bit. So is there anything else on the MLS that we wanted to talk to before wire fraud?
One other thing is that for those of you who do have a website, whether you're a broker or you're an agent and you have a IDX feed or you have something that is displaying, photos of property or anything that doesn't necessarily come from you, meaning there's other people posting things or there's other information, other real estate, other MLS listings coming to your website, you should have what we call a DMCA notice, Digital Millennium Copyright Act, which is the federal statute that provides for somebody bringing a copyright claim if you're posting or displaying a photo that does not belong to you and somebody sees it on your website and says, hey, that's my photo, that shouldn't be up there, and they write you a demand. And so the DMCA notice on your website gives you a safe harbor, meaning that they have to give you notice and time to pull it down, and then you have no liability. But you got to have this DMCA notice on your website. We did an article on this in the past on the process of getting this on your website. If you go to har.com terms of use, paragraph 17 and 18, you can see our DMCA notice, and it does happen. We had an agent list a photo a while back, and it happens every so often, and we got a letter from a photographer saying, hey, they don't have a right to have that photo up. But we had no exposure because we had a DMCA notice on our website that protects us from, alleged copyright infringement. So I don't want to get too much in the weeds here, though, but it's something that if you have a website displaying information or photographs, intellectual property that does not belong to you necessarily, then you should get the DMCA notice on your website.
Good. So Susan just mentioned HAR form 302 is the vendor photographer agreement form. So
there you go.
If anyone was wondering, there you go.
Thank you.
Thank you for sharing that with us, Susan. Lois, to talk about photos just one more time. On the question about the rights to the photos, if the other listing agent took the photos for the owner and put them in the MLS, can the owner have rights to those photos and give them to the new listing agent?
No.
Property. Okay.
Typically, no. I mean, not unless the owner had a side agreement with you or with the photographer, but typically that doesn't happen that way. Okay. So short answer, no.
Very good. So I wanted to talk a little bit about wire fraud. We did discuss wire fraud the last time you were here. So are there any updates to the wire fraud situation, and what can we be doing to protect our clients and customers?
Well, I think we had a meeting with if I can find my notes here, FBI special agent about this, because I don't know whether it was either right before we last met or right after we last met. I
think it was right after.
Everything started blowing up on wire fraud.
Sure.
And so we had a meeting, and the FBI basically was saying things that you may already know. I mean, it was almost an affirmation of what we were already telling. I think we had a email blast. We being HAR had an email blast about do's and don'ts. I'm sure I think there was some TAR stuff that went out. I think there's now a TAR form that alerts the parties to a transaction of the risk of wire fraud, which is an important form to.
So that was actually mention this. That was actually what Karen was asking about earlier. The new wire fraud TAR form, should they attach it to all listings and contracts?
Well, yes.
Yes. Okay.
I mean, it certainly comes into play. I'm trying to remember whether it's an add-on to the listing agreement or to the contract, probably more so to the contract, because it doesn't come into play until that moment in time. But it's I think the general rule is that, and I think we have a new MLS rule on this, is not to identify the title company, because what the FBI told us is that the commonality in some of this wire fraud is that the hackers or the people that were getting involved in the process were able to, since they were able to see who the title company was or know who the title company was, that's how they set themselves up to receiving the wire fraud instructions versus the actual title company.
Okay.
So they kind of jumped into the email or to the exchange of information by email, and all of a sudden the agent or the seller or any of the parties' agents were getting emails from a bogus title company, same name but bogus email. And people weren't really realizing that the email was actually a little bit different.
Right. They're not paying close attention.
Well, and you wouldn't,
from.
and so understandably. And so that's why the title company issue came about, as far as not putting that in the MLS, not trying as best you can, not putting it in an email, even though it's hard not to have a PDF attachment with the contract that may include the title company.
Sure.
So there's limits to what you can do, and the wiring instructions should never be in writing. They should always be verbal and should be confirmation about that. So don't email the wiring instructions. That was the other one. Apparently hacking Gmail and Yahoo and those big accounts like that is a lot easier than one might think.
Yes, it is.
And then, if there is a wire fraud, I mean, you should immediately, if you suspect it or actually experience it, or your client does, there's a website, ic3.gov. So ic3.gov. If you go to that website and you alert, and that's an FBI website, literally, they told us people sitting in Washington, D.C. waiting for stuff to come in. And once it comes in, they jump right on it. So I guess there's a way they can, through the federal banking system, can maybe grab a wire or shut down a wire before it gets away to the wrong party. So it's critically important that on the suspicion or the actuality of a fraud happening, that you go to that website and report it.
Okay, great. Karen did also add the number for that TAR form. I love that you guys are looking those up for us. It's TAR 2517. So that's the TAR form that you were mentioning.
On the wire fraud.
On the wire fraud, yes. Sorry about that. Okay, so going back really quick to the photos again, Angie's asking, I understand the DMCA notice, but can an agent use your same verbiage, as in property description, when relisting the property? So we were specifically talking about photos, but she's talking about the verbiage now. Is it okay to?
No, I think you need. I mean, if you're taking on a listing of a property that was previously listed, then part of kind of creating this information that is unique to the property starts with you. And so I would not use what was created by the previous listing agent. You create your own. Now, where there be some overlapping, I mean, you can't help but overlap the address and other featers, too bad. I mean, there's certain things you can't help but.
If it's a 4-bedroom, it's a 4-bedroom, right?
But I mean, as far as the adjectives, if you will, I mean, let's try to be unique and creative on that.
Okay, very good. So we've actually had quite a few episodes, a lot of information about Houston's new flood ordinance. Excuse me. Is there anything that our members should be aware of? That specifically that you've noticed or you want to kind of address with them?
I think it's a big deal, and I think you as a buyer's agent, especially, it's a big deal. If you're representing a client looking in perhaps an old neighborhood, which with houses that are perhaps in transition, meaning some of the neighborhood is being torn down, some not, meaning for example, Braze Heights, or any a lot of home. Well, it doesn't matter inside or outside the loop these days, but ranch houses or houses that are 30, 40, 50 years old, or any sort of neighborhood that's in transition, you need to be aware of the floodplain ordinance, which is Chapter 19. You can Google it. It's Chapter 19, City of Houston Floodplain Ordinance.
We just put up the website for them too, so they can see
And
it.
it's the reason it's critical because if your buyer, and that you should have this discussion with your buyer, if they're thinking of maybe tearing down this house one day and rebuilding, or something they should maybe, even if they're not thinking of it, then maybe they should start thinking of it, that may come up down the road that they may want to tear down and rebuild. Well, they need to be aware that how they view the house now is not how it will be viewed in the future as far as its height, how high the level of how high it will be. And so the new floodplain ordinance means that if you build anywhere, new construction and material remodel, let's call it, anywhere in the floodplain, whether it's the 100-year or the 500-year, the finished floor has to be 2 feet above the 500-year floodplain. Now that's a mouthful. And so the old ordinance was if you build in a floodplain, you had to be 1 foot above the 100-year floodplain level. That's been changed. And so now you have to be 2 feet above the 500-year floodplain level. And so depending on where you are, that's significant. I mean, that could be the difference between building 5 feet off the ground or 8 feet off the ground, or building 3 feet off the ground or 5 feet off the ground.
Sure.
And so it's significant in that some people don't want to be in a house that high, okay? Or some people don't want to spend the money to build a house that high. Or some people don't want to, maybe just from a curb appeal, don't want a house like that. Or maybe they just don't want to be in a neighborhood where that's transitionally down the road, if they had to sell it or rebuild themselves, that they would be subject to that ordinance. So I think it's something as a buyer's agent you should be aware of, especially with couples that are maybe down the road going to transition from the current size home maybe to a bigger home in a particular neighborhood that they may like.
Okay. And actually, just to add to that, we did have Jamila Johnson with the City of Houston on October 1st. We had her as a guest, and anyone who wants to know more about the flood ordinance, I would suggest going again to our Facebook page, watching that video. She did an excellent job of explaining it to us. Also, we are offering a class at HAR. It's being taught by Bill Baldwin, and I think there's a couple dates left. If you go to har.com/edu, you can look it up. It's, I believe it's something along the lines of a realtor's survival guide to the new flood ordinance. So I would check out those classes and that video. If this is new to you for whatever reason, I would go check that out. Karen is asking, how do we look up flood maps in Matrix? Karen, it's actually when you're in the map in Matrix, there's an overlay for flood maps. Now, just keep in mind that is the most up-to-date FEMA map, which has not been updated post-Harvey. So,
and won't be for several years. Right.
So that's, it's in there. You can look it up. But once they update, of course, it'll be updated in the MLS as well.
Something in this, to the extent it's a really big issue for your buyer, and this may require some legal advice for them, but maybe the contract should be subject to what the survey shows as to where the 500-year floodplain is as it runs across the property. So I mean, I guess what I'm saying is ultimately the survey, if you go that far into a transaction, will show you that. And you say, well, the seller may have a old survey. Well, that's the problem with it. I mean, old surveys may not be that accurate, and most surveys don't show the 500-year. They usually just show the 100-year. Mm-hmm. And so if you're in a situation with a buyer who has a lot of this ordinance on their mind, and then ultimately the way to know where you might have to build in the future is you get a survey showing you the 500-year flood line as it passes across your property. And as Christina said, that's current. That's probably going to change again, or there will be another FEMA map coming out because of Harvey in the next however many years. Nobody has an exact timetable on that, but they will redo the maps, kind of like they did after Allison.
Yes.
In 2001.
Yes. Absolutely. And like I said, if you didn't get a chance to check out the interview with Jamila Johnson on October 1st, go look that up. She did provide some resources, information about how to get in contact with her office if you have any questions. So they're really busy over there, as we can imagine, but she did provide a lot of resources. So go look at that if you haven't yet. So kind of my final question for you, Grant, and then of course, if our members have any other questions, we can get on those. But just kind of what do you see coming maybe in the next 6 months to a year as far as truck regulation is concerned?
Well, so that's a good question. So Trek, as you may or may not know, was recently audited by what they call the Sunset Commission. So most state agencies go under an audit performance by a commission called the Sunset Commission to see how they're performing and whether they're serving their purpose. And lo and behold, Trek went through one. And to be honest with you, the news was not good for Trek. The Sunset Commission came back with a lot of deficiencies in how Trek had been conducting business, which some of you may already know that from your own experience, just as far as timeliness, access, use, responsiveness, basically getting things done and serving not just licensees, but the consumer too. And so the Sunset Commission pointed out a lot of things that were wrong with Trek. And so, and some of those were, burdensome regulations or unneeded regulations, or not just caring for the core values of the agency. And so I think what to expect in the future, hopefully, is a more focused Trek, a more timely Trek, a more responsive Trek, a Trek that will just try to manage what they have versus creating new things to manage. And so that's good news for licensees, and it's good news for consumer, because it seems as if they'd kind of gotten off the tracks up there, and this Sunset Commission kind of, if you will, put a leash on them. And now in the future, I think you'll see a better performing agency that protects consumers and provides you proper guidance.
Okay, that's wonderful. Okay, so that is all I had for you. Is there anything else you wanted to add?
No, I think that was it. I'm looking at my notes, and if we could
probably go on all day if people really wanted us to.
But
right? All right. Well, thank you guys for tuning in, and thank you so much, Grant, for joining us again.
Thanks for being here.
We love hearing from you. So we will be back next week, same time, same place for Member Focus Monday. Thank you. We'll see you then. Bye-bye.